The next case to come before the court is Parkplay Solutions LLC, the City of Avon Lake et al. I don't know if either of you are waiting on any other folks to join you, or if you're...
I am not.
Okay.
No, you're right.
Okay, very well, then I'll give you a moment to get organized, and if you're ready to proceed, we can get started. Let me just say at the outset that each party will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please keep your voices up. You should introduce yourselves, but please do not use the names of children or minors or victims, should that be relevant to your argument. You can refer to those folks by initials or generic terms. We have read your briefs and we're ready to proceed when you are. Counsel, would you like to reserve time for rebuttal?
Yes, I would.
And how much?
Only 2 or 3 minutes, I think.
Okay, I will go with 3 then, and I will let you know when that time arises.
Thank you.
And you may proceed when you are ready.
Good morning, Your Honors. My name is Keith Savage. I represent the appellant, the City of Avon Lake. I would be remiss if I did not introduce my colleague in the back of the courtroom. She is a second-year law student, not at Akron, I'm afraid, but she is at Ohio Northern. And she is interning with our firm this summer and has come along to observe these proceedings. This case, as the court is aware, involves the city's right as a home rule charter city to adopt its own procurement procedure for the acquisition and installation of playground equipment at a local park. And the trial court's what we believe to be erroneous conclusion that it had no such right. We see this more as a home rule case as it is to a procurement technicality case. It's not news to this court that charter cities are empowered with great authority to self-regulate. In this case, the quest to replace and upgrade the playground equipment started in early 2020, but was then delayed due to COVID. And an architect was hired to come up with a design for this new playground in the park. Unfortunately, both for the city and for the architect, when the architect presented to the city council was totally underwhelmed by what they were receiving as a proposal. Testimony was that they were looking for a wow effect. They were looking for something that would be distinct and impressive, and what they got was not it. So this city council formed a committee of 8 people that was variously comprised of council members and members of the city administration. And they entered into a process of identifying companies that could provide this service. Plaintiff was one of the companies that was invited to participate in this process. They went through an interactive process of interviewing, providing information, receiving information back, and they culled this down from 4 proposing companies to 2. Once again, the plaintiff was one of the companies that was selected. They continued that process by refining it, fine-tuning it, giving additional information, receiving additional information, until ultimately this committee of 8 focused on a company called Mid-States. Mid-States, it was recommended to the city council, should be awarded the design-build contract to construct the new playground. This lawsuit ensued. The lawsuit was filed, I believe, in early January of 2022. The court was asked to issue a temporary restraining order. The court declined that and refused to grant the restraining order. The city then proceeded to pass an ordinance and to award a contract. At this point in time, the plaintiff sought permission to file an amended complaint and then filed a second temporary restraining order. This time, the court granted it. A week later, we had a hearing on a preliminary injunction, and pursuant to the rules, we combined the hearing on the merits with the trial. So it was the whole enchilada that was tried. And then the court went ahead and published an opinion approximately a week later. The court concluded three things. The court said that we failed to follow our charter, our state law, and the ordinances regarding the competitive bidding. The court said that the contract that we had entered into with Mid-State was void, and the court said that Mid-States could not be paid under the contract. The city of Avon Lake and our amicus partner, the Ohio Municipal League, as you're well aware, they've submitted an amicus brief in this case, contend that the court was wrong and failed to recognize the broad home rule powers that were given to the city.
Let me ask you, because you're moving through your time here, and direct your attention to the ordinance number, whether 21186, it was the ordinance approving this contract with Midcast, or whatever their name is. In there, you say in your ordinance that this was done pursuant to revised code for the design bid purpose, and you don't say anything about it being done through the charter.
Yes, we do, Your Honor. It's in the same thing. If you look at the ordinance itself, whereas in accordance with the city's charter, it's the second to last whereas clause.
The second, is that in ordinance number 21186?
Yes, I'm looking right
The
at it.
ordinance passed in, that would have been, I assume, January, February of 2021.
Yes, Your Honor.
And they're saying that, you're saying there is a whereas it says it was done pursuant to the charter.
Whereas in accordance with the city's charter and the Ohio Revised Code, the city is authorized to enter into.
But the trial court did not find that whereas. To me, they're saying that whereas was earlier in the process, you said you're doing it pursuant to the charter.
Well, if that's the trial court's finding, that's another error. I mean, I'm looking at the ordinance right here.
Okay. And what exhibit is that? Do you have can you tell from your brief what exhibit is that from the trial court record? That ordinance that you're looking at?
Yes, it's exhibit KKK.
KKK?
Yes,
Okay.
and I believe it's exhibit 1 or 2 in Mr. Rosenbaum's exhibit.
I'll review that, thank you.
Pardon?
I'll review that exhibit, thank you.
Thank you. Okay, so if you look at our charter in exhibits, and the court cites to it in its decision, but the powers clause of these charters are front-end loaded, right? So you start off with a general right of what you're getting in your charter. This one says, the municipality shall have all powers of local self-government now and hereinafter granted to municipalities by the Constitution, etc. Then it says, and such powers shall be exercised in the manner prescribed by this charter and council. Charter and council, 2 points. And then the third point of this is that the enumeration or reference to particular powers in this charter shall not be construed to be exclusive. Now, we have section 59 of the charter that does talk about competitive bidding. but it also has opt-outs or exceptions to that, and it has several categories which may or may not be applicable to this. But the point is, that listing of 59 does not limit how we procure, because we have broad powers under the charter. The court said there's nothing in this charter that now enables you to do what you did in the manner that you did. That is the wrong question. The question is there anything in this charter that precludes us from doing that? And there is nothing. Let me move on to another point here, and that is what I will call the ratification concept. In the back of this charter, in section 71, there is a provision that says that the power is invested in council to interpret the various sections and parts of this charter in harmony with the spirit thereof by ordinance of said council adopted by the affirmative vote of 5 or more. In other words, supermajority, that brings this section into play. That same ordinance that you and I were just discussing, Your Honor, was passed by a supermajority, so that the city council had the authority to cure, if you will, any defect in this procurement process. And that is the case law of the state, that charter cities may do that. And we gave you several examples in the brief. In the interest of time, I won't belabor them. They're there to see. The last point that I want to stress is the concept of movements. As I indicated when I recited the statement of facts, by the time this case came before the court, the contract had been awarded, the playground had been cleared, the ordinance had been passed, the contract had been awarded, and the successful offeror had ordered equipment. Under Ohio case law, if you don't get a TRO before that happens, your sole remedy is bid preparation costs, and that's it. We filed a motion to dismiss. The court overruled that. We set it up in our answer as a defense, and we asserted it in our arguments before the court on the days of trial. Nowhere does the court address that, I believe, in its findings in the ultimate decision, although it does appear on the record. So we're saying, no, you had no jurisdiction, Judge, because this issue was moot at that particular time. We just heard that in another case, I guess. So I'm going to reserve the rest of my time. Thank you.
Okay, you will have just over 3 minutes for rebuttal. Thank you.
Thank you.
Counsel, would you like to proceed?
Good morning. My name is Jonathan Rosenbaum. It's my privilege to appear before you on behalf of Parkplay Solutions, Inc. I respectfully submit to this court that what this case really involves is the responsibility and transparency of government. What occurred in this case, the procedure used by Avon Lake, is more than telling when it comes to viewing the propriety of whatever it's trying to do here. First of all, Avon Lake started out saying this was a design-build project, and even passed an ordinance that said so. Then, after Parkplay pointed out that they didn't comply with the design-build process, they changed it to being a cooperative purchase. When Parkplay pointed out that they failed to do that properly, it changed it back to a design-build, and that's the ordinance in question. Now, the Ohio Municipal League is saying it's not a design-build, it's not a cooperative purchase, it's a contract for personal services, which is also contrary to their own charter. Charter cities have to comply with their own charters. Apparently, Avon Lake and the Ohio Municipal League doesn't see that as a vital concept of being a child city, a charter city, I'm sorry. Despite the language in its charter, Avon Lake does have to follow the revised code because the charter calls for it. Mr. Savage argues that there are exceptions in section 59 of the charter under competitive bidding. He's correct. The general rule is that they have to competitive bid something over a certain amount set by state law. Then there are exceptions, but to comply with those exceptions or to avail yourself of those exceptions, you have to comply with what they say. And it's expressly written in this charter that you can do a design build according to the laws of the state of Ohio. Well, they didn't. And that is the gist of the trial court's ruling. They may have had a committee 8, but they did not have a design build professional, which has to be an architect or an engineer. And they admit this in hearing. It's uncontradicted. They can't get over that hurdle, yet they argue all these alternatives. The fact of the matter is, if you're going to comply with the written exception in your charter or profess to do so, you better adhere to the procedure set forth in there. And the revised code is very specific about what a design build project can be. And if you follow that, then there are safeguards built into that, which necessarily obviates a bid requirement. And a bid is not necessary if you have all those precautions. They had none of those precautions, and their committee of 8 does not comply with the Ohio Revised Code, and therefore the process was invalid. Their ordinance says that it is pursuant to the charter and the revised code. The charter calls for compliance with the revised code. The revised code speaks for itself, but they failed to do so here. Now, the construction did not commence on this project, making it moot. The law relied upon by Avon Lake Municipal League is the Gainer case, and that says it's moot when events occur without the fault of either party. In this case, the fault was entirely Avon Lake's. Avon Lake tried to rush the ordinance through to make this moot, and therefore they can't avail themselves of that law. They try again, for some reason Avon Lake just doesn't want to obey their charter or the Ohio Revised Code, and their attempt to rush this through to create mootness fails under the law that they cite.
If we were going to find that Avon Lake did not do anything wrong and pass their ordinance after the first injunction was denied, are there other reasons why it would not be moved?
I'm not sure I understood your question.
Well, I mean, is your only argument that it is not moved because Avon Lake acted improperly? Do you have any other reason to tell the court why it's not moved?
No, my argument is Avon Lake, it's not moot because construction hadn't begun. That's a separate issue. They acted improperly. They're trying to cure that by saying it's moot, you can't hear it. But the fact of the matter is construction had not begun. The case law says construction has to begin. They admitted construction didn't begin in their closing argument on page 203 of the transcript. So I view that as two separate issues. Now, for the first time, there's two arguments they're raising for the first time at this level. At the appellate level, I think it's improper. The first one is that they're trying to interpret an inconsistency in the charter. The section of the charter that they rely on says if there's inconsistencies in the charter itself, not an inconsistency with having to comply with the revised code that the their charter required. They did not find an inconsistency. The city council did not say our charter is inconsistent in and among itself. We're remedying this with a vote. The fact they voted on an improper ordinance is not the same as finding an inconsistency, nor is it ratification of an improper ordinance. There's no separate ordinance here saying we realize what we did wrong, here's how we're going to fix it. They're trying to say we don't have to comply with our charter or the state law, which is totally improper. Their charter does limit what they do and how the exceptions apply, and they failed to adhere to that. they can't rewrite legislative history and say this is no longer a design-build process which they failed to comply with. And that's what they're trying to do here. Avon Lake can't correct this fatal flaw retroactively by claiming the project is something other than what they said it was, by claiming that they ratified it when they didn't, or by claiming that there's some kind of inconsistency in their charter which doesn't exist. For some reason, Avon Lake doesn't think that its own charter or the revised code applies to it when their charter incorporates the revised code. And that is what the trial court properly found when they said, basically, you messed up. And their attempts to remedy that retroactively should not be sanctioned by this court. Otherwise, the legislative process really means nothing. Why have 3 readings of an ordinance at council? If you can pass a council, you tell the public what you're gonna do, this is how we're gonna do it, and then say, never mind, we're not doing it that way. That's not what government's about, and this court should not sanction that. Thank you.
Thank you, counsel. And you will have 3 minutes on rebuttal.
Your Honors, with no disrespect to those of you that may have served on the state legislature, the state legislature has no authority to tell a charter city what can be done for procurement of something that is so local as a park. The statutes that are being applied here have absolutely no relevance to the procurement process applicable to a charter city. Those are things that apply to state agencies and non-charter cities. They don't apply to us. The provision of our charter that Mr. Rosenberg was referring to was adopted in 1951, probably 30 or 40 years before anybody came up with the concept of design build. The reference in the charter talks about for any purpose for which contracts may be awarded by a municipal corporation. Purpose, subject. It doesn't say, and you shall do it in accordance with the way those statute reads. How we do it is up to the local home rule authority of the city of Avon Lake. And as I said in my opening, what we put in the charter is enumeration by reference and is not construed to be conclusive. The power stems from section 2. And then when council finally acts, they are approving the entire process. That is what the case law says. Any deviations, they're fixing it. So in our judgment, what was done here, perhaps with some false starts, but trying to get kids a park in a local community is up for the city of Avon Lake to decide how to do it. They had a transparent process that involved the entire community, and plaintiff was all in until they weren't, until they learned that they weren't going to get the project. That's when they became upset. And I don't think Mr. Rosenbaum can get around the mootness argument. Thank you very much for your time, Your Honors.
Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you again.